welcome to Deb's True Crime Notebook. Richard Allen will be in court tomorrow for his hearing. There are several things that will be talked about in the courtroom. This video will examine several of those things. A motion in limine is a motion filed by a party to a lawsuit which asks the court for an order or ruling limiting or preventing certain evidence from being presented by the other side at the trial of the case. What is the difference in suppression and in limine? A motion to suppress is typically filed by the defense in criminal cases. It's a request to exclude certain evidence from being presented at trial. This motion argues that the evidence in question was obtained illegally in violation of the defendant's constitutional rights and therefore should be deemed inadmissible and excluded. It's a stick to keep government from just going around violating everyone's rights in the name of justice. A motion in limine is a pretrial motion filed by either the prosecution or defense in civil or criminal cases. It seeks to exclude certain evidence or information from being mentioned or presented during the trial. The purpose of the motion is to prevent improper, potentially prejudicial, or irrelevant information from influencing the jury's decision or prejudicing the case. It allows the court to determine the admissibility of evidence in advance, reducing the risk of improper or prejudicial statements being made in front of the jury. Let's hypothetically examine why the judge could throw out the ballistics evidence. What if the search by which the gun was obtained was unlawful? And then there is an independent issue with the unspent shell casing that allegedly matched that gun. Could the motion in limine address a lack of relevance, possible chain of custody issues, and or lack of foundation? If so, the state's case could be weakened. We all remember the information by neighbors of what was brought out of Richard Allen's house. For example, a shopping bag from Macy's, a shoebox, and a stack of books, etc., dark clothing. If that was visible to neighbors, was it actually acquired and taken care of properly? Later in this video, we're going to examine the proper way that law enforcement must handle evidence. And who can forget that there was a person who claimed to have found something at the crime scene a week after the murders? Law enforcement showed up on February 17th to do another search of the area. So let's examine a quote from that person. Yeah, I was out there about a week after the murders. I did find something covered in blood. I took it to the command center. I talked to the FBI. I submitted my DNA to be excluded. And the FBI took the pictures off of my phone and asked me not to say anything to anyone because it could hamper the investigation. We all know that Richard Allen has some very skilled attorneys. Andrew Baldwin is one of those attorneys. Let's take a look at his experience with this particular issue. In the case of Caden Smith, Richard Allen's attorney, Andrew Baldwin, got the murder weapon thrown out because of a search warrant issue. That didn't finish the trial, but it made it so that the suspect could be waiting on home house arrest instead of going to jail. Could this be the reason for the motion regarding ballistics in the Richard Allen trial? I'm going to let you take a look at the Indiana rules for handling evidence. You may need to use the stop and pause button, but take a look at the information here, and we'll be right back. more things that will be discussed tomorrow in the Richard Allen hearings. 1. Setting a trial date. 2. A motion to suppress ballistic evidence, which we've talked about. Number 3. Whether to keep Allen in a state prison or move him elsewhere. 4. Approval of a defense expert. Join me at 8 a.m. tomorrow for full coverage on True Crime Talk with Frank Meister. I will be co-hosting with Ruckus Rocks on Frank's channel. We can't wait to see you at 8 a.m. tomorrow. Until then, so long from Deb's True Crime Notebook.